Okay, good morning, everyone.
Morning.
Good morning.
Morning, Your Honor.
Good morning.
This one, you could probably remove your mask.
Oh,
Okay, let's make sure we have everyone present for the first case, Delvin versus CUFFY. We have Attorney Manning.
Good morning, Chief Justice.
Good morning. And where is you arguing? Okay, so you're present. Okay, you're shaking your head. Just okay.
I'm present. Good morning.
Very well. And for Atlantic Human Resources et al. Versus Epperson.
Good morning, Your Honor. Andrew Simpson for Atlantic Human Resources.
good morning,
Okay.
Judge Samaj Johnson for Sugar Bay.
All right, and Attorney Lawrence, you again?
Yes, me again. I
Okay.
believe there's one more for the defense side, for the appellants.
Okay, yes, Roberts versus the people. Well, Attorney Dowling.
Good morning, Your Honor. I'm present.
Okay, we don't see you, but
Trying to get the microphone off. Here it is, Your Honor.
okay, good to go. And for the government on that is Attorney Clement. Who's arguing?
No, Your Honor. Good morning. Attorney Kenneth Case.
Okay. Okay, so we've got everyone. We will now proceed with the calendar for today, starting with the first case. Delvin versus CUFFY. That's number 64 of 2019. Attorney Manning, do you wish to reserve any time for rebuttal in that case?
Yes, Mr. Chief Justice, I ask that I be permitted to reserve 5 minutes for rebuttal.
Very well. So you may proceed.
Thank you. This case involves whether or not the appellee had an easement. There was no evidence on the trial record that demonstrated an easement, other than parole evidence, which was introduced by the territorial surveyor in reviewing maps. We submit that the finding that there was an easement violates the Virgin Islands Statute of Frauds. Clearly, an easement is an interest in real property, and it would have to be recorded. There was no such evidence that was introduced on this trial record. We submit that the order of the Superior Court was not a final order. It did not comply with Rule 58 insofar as there was no final judgment that was entered in this case. We also submit to this court that the trial court used the preliminary injunction standard in adjudicating this matter on the merits, insofar as it denied and dismissed the claims using the preliminary injunction standards, which would be inappropriate for a trial on the merits. Rule 52 would govern the findings of fact and conclusions of law, and that was not complied with in this case. Clearly, what the appellant sought was the issuance of preliminary relief, a preliminary injunction, pending an appeal of a DPNR order to the Board of Land Use Appeals. In this case, the trial court decided that it would serve as the Board of Land Use Appeals and rejected the plaintiff's request that this matter be adjudicated there. And based on that, we submit that our clients demand and request to have it procedurally go through the process of the Board of Land Use Appeals was denied. And it was denied without a significant explanation. We also submit that my clients had filed, along with the temporary restraining order and preliminary injunction application, an issue, a trespass issue, which should be, and under the law, should be tried by a jury. Rule 38 demand was made, and the only way we submit that the court can usurp that authority and have a bench trial is through the consent of both parties. In this case, the court ruled that it would be the finder of fact. Therefore, there was no consent. There was no opportunity to consent or reject to that. And we submit that once the court rules, then there is no opportunity to waive or consent or challenge or anything else. And that's what this court, that's the purpose of this court, because once you have a final ruling, then it's up to the Virgin Islands Supreme Court to determine whether or not that ruling of the court.
Attorney Manning, you have very briefly mentioned Rule 58 in your briefs, but now you are arguing regarding the entry of a final judgment and Rule 58. Are you arguing that this court does not have jurisdiction?
My argument is that not that the court has no jurisdiction, but because the court can rule.
Well, if we have jurisdiction, then why are you mentioning the purported lack of a final order?
Well, my argument, Justice Cabret, is that the court has jurisdiction in some cases over preliminary injunction matters. I mean, not only do you have, appellate jurisdiction over final judgments, but in certain cases where the court does not intend to act any further, the court would have jurisdiction.
But I'm questioning you regarding your argument about the lack of a final judgment or order. And it seems to me that even by mentioning that, well, I don't know why you're mentioning that if it doesn't go to jurisdiction. And if it does go to jurisdiction, it seems to me that you're arguing against your position, because what you're saying is, Judge, we who brought this appeal have no business in this court. Please kick us out.
No, Madam Justice. I'm arguing that there is no final judgment. However, based on the principles of equity, the court can rule on a preliminary injunction matter. I mean, the court can come out and say, listen, we've seen where this court, where the trial court is going as far as.
Let me get to a more important issue.
Thank you.
Where in the record did the trial court ever tell the appellants that they could not go to the Board of Land Use Appeals?
It's my argument, Madam Justice, when the court said it was not going to wait for the Board of Land Use.
At the time that the court said that it was not going to wait, had the appellants filed anything with to this date, have the appellants filed anything with the Board of Land Use Appeals?
No, Madam Justice. My argument is that when the Superior Court.
Have the appellants now file anything with the Board of Land Use Appeals?
Equitable tolling, Madam Justice. Our position is once the Superior Court ruled, there was no activity for the Board of Land Use Appeals, because the doctrine of res judicata would have barred the Board of Land Use Appeals from finding anything contrary to the Superior Court. Because procedurally, it would go from the Board of Land Use Appeals to the Superior Court on appeal. And once the Superior Court rules, there's nothing for the Board of Land Use Appeals to do. It would have been a matter of res judicata. No other court, assuming that we go back to the Board of Land Use Appeals and then appealed it back to the Superior Court, no other court could have touched it, because the matter would have already been resolved on the merits by another Superior Court judge, the very same issues. So once the Superior Court decided that it was not going to allow or permit the Board of Land Use procedure to occur, then it's our argument in its entirety.
But how can you say that the court, decided that it would not allow the Board of Land Use Appeals to occur? The Superior Court didn't make any ruling. It simply said it was going to proceed, and that didn't prevent you from continuing your appeal with the Board of Land Use Appeals, did it?
Mr. Chief Justice, we're arguing as a matter of equity. Legally, we believe it would have. And the reason we're suggesting that is because the Board of Land Use Appeals is not a higher authority than the Superior Court. So the Board of Land Use Appeals.
But isn't the Board of Land Use Appeals the authority over or change permits, any permits issued by the Commissioner of Planning and Natural Resources?
Yes, Mr. Chief Justice.
So what did the Superior Court do that took away that authority?
The Superior Court ruled on the merits. It ruled that there was an easement, and if the Superior Court found that there was an easement, then the Board of Land Use Appeals would have been required at that point to find that there was an easement. Therefore, that was one of the issues that was being challenged. It would have been challenged down below.
But wasn't there environmental matters that the Board of Land Use Appeals could have considered?
Absolutely, and those are some of the issues that the Board of Land Use Appeals would have considered, but they would have also had to.
But what prevented them from considering them, other than the fact that you hadn't filed a notice of appeal as of yet?
Well, the problem, Mr. Chief Justice, would have been the Board of Land Use Appeals would have had to determine whether or not the sliver of land, the appellee was entitled to any action on that sliver of land. And once the Superior Court found that it was, and that was one of our principal arguments that just went out of the door. And so otherwise, what would have happened is you would have had a split.
So you were saying that the Board of Land Use Appeals could have resolved the issue of title to those roads?
It could have decided the issue of whether or not the appellee had a right to that land or a right to.
I thought the only thing that would have appealed is whether or not the earth change permit issued was proper.
Well, to determine whether or not the earth change permit was proper or not, it would have had to determine whether or not that the appellee had a right to the land in the first place.
Yeah, Attorney,
Yes.
I have a couple of questions, because the more I'm listening to the dialogue, the more it seems to me that we need some clarity here. My understanding is that originally, your original complaint cited trespass, and you were seeking a TRO, viz. Also a permanent injunction to have a stay of any proceedings from an appeal from DPNR to the Board of Land Use Appeal, and that your client suggested that they were going to appeal the earth change permit given to Mr. CUFFY, so that you were going to resolve the issue of the permit before the Board of Land Use Appeal. But somehow other issues seep into all of this, and then we had a full-blown trial where the judge consolidated the TRO along with the permanent injunction. But other issues are raised. But I must say that I don't understand how the Board of Land Use Appeal, when if you had appealed properly, would have been only the permit that was issued to Mr. CUFFY could ever get into title, trespass, servitude, and all of these other issues.
Justice Swan, they would have had to determine whether or not the land, the underlying land where the earth change permit was being issued for, the appellee had a right to it. I mean, for example, I can't get an earth change permit for to change the earth on my neighbor's land. And that's precisely the first matter at hand that the Board of Land Use Appeals would have had to address. And the reason it seeped out in this case is because there was also a trespass issue that was involved. And when we had the trespass issue, the court had to determine whether or not the appellee was wrongfully on that land. So it had to
but would you not agree that you initially, and all through the dialogue in the appendix, the whole issue was getting a TRO and the permanent injunction to stay the proceedings in order to allow you to appeal from DPNR up to the Board of Land Use Appeal. Am I correct? That's what was the initial step in coming to court, afterward this thing of trespass and all these other issues came in. But that was the reason why why the complaint was initially filed. That's what I understand.
Absolutely, but the problem was the trespass issue. So it had to determine title on the land in the first place. And once the court determined title, then that was an issue that Blue could not determine at all. So that's my argument.
Even if the court had granted you a TRO or a preliminary injunction or whatnot, or hold the proceedings before the court in abeyance pending the appeal that you were supposedly was looking for, apparently no steps, affirmative steps were taken to even to pursue that appeal.
But it's our argument, Justice Swan, when the court decided that it was going to have a trial on the merits and not wait for Blue. It's our interpretation and our position today, and it's been our interpretation from the very beginning, that there's nothing else for Blue to do.
No. As long as there are the laws that give a right to anyone to appeal from DPNR to the Board of Land Use Appeal, irrespective of what the court is doing, if you want to appeal to the Board of Land Use Appeal, you can go ahead and do so. Because the court never enjoined anyone from appealing.
That's correct.
But it could very well be that because there was no appeal, no activity, the statute of limitation for appeal had expired, that the court decided, well, I'll go ahead and I will decide the case on the merits.
But the statute of limitations, Justice Swan, had not expired at the time we were before the court. That's my argument to you. And if
it didn't expire, then why did you go ahead and appeal?
It's our position that when the Superior Court decided that it was going to rule on the merits, that there was nothing else for the Board of Land Use Appeals to do.
I totally disagree with that.
Okay, Justice Cabret, you can ask your question, and then I'm going to ask one question, and then we've gone over almost 4 minutes.
Attorney Manning, did the trial court ever tell the BABJIs that they could not go to the Board of Land Use Appeals?
No.
And didn't the trial court remind the BABJIs that they were not before a jury? And in fact, didn't the trial court, because you're arguing about the denial of a trial by jury, but aren't you in a court of equity? So you're not allowed a trial by jury in requesting equitable relief. The jury trial request was as to the trespass claim. And as to that claim, didn't the court specifically ask the BABJIs, are you asking for a jury trial on a trespass claim? And there was a very vague answer. Well, Your Honor, we're asking for it, and I'm paraphrasing here. We're asking for it because if we don't ask for it, it's going to be deemed waived, but we'll deal with that later. And then after that colloquy with the court, exchange with the court, the trial counsel never, ever, ever mentioned, despite the fact that they knew that there was a permanent hearing going on, never, ever raised that issue again. Never said, Judge, we want to try the trespass claim before a jury. So, isn't that waived? That's my point.
No, absolutely not. Rule 38 requires consent from both parties. And we don't believe that any of the language that was used ever consented to a trial by bench as opposed to trial by jury. There was no consent. He never waived it. When the court made its ruling.
Does the court need consent to consolidate the matter on the merits along with the preliminary injunction?
It's our belief that absolutely yes, Rule 65 requires it. And there was no waiver and there was no consent under Rule 65, Chief Justice.
Did you
Well, Attorney, you were trying to rewrite Rule 65. Look at Rule 65, because my understanding of Rule 65 is that once a TRO is granted, a court can alert the parties that we're going to have a hearing on the preliminary, but I am going to consolidate so that the evidence that can come out on the preliminary, we won't have to rehash or regurgitate on the permanent injunction. Now, you are saying that somehow that the court needs permission from the litigants in order to consolidate?
Well, it's our belief based on how we.
No, I'm not talking about your belief. What does Rule 65 say? Does Rule 65 give you that authority? Because then I got to go back and read Rule 65 again.
Well,
Unless you change it.
Yeah. Attorney Manning, think that over, check your rule. We've gone over 7 minutes of your time already. So think about that, and I want you to think whether or not our recent decision in strike back, does that affect the merits of your case? So with that, we will proceed to hear from the appellees in this case.
Thank you, Chief.
Attorney Lawrence, you may proceed.
Thank you, Your Honors. The complaint in this case was originally filed April 24, 2019. At that time, the representation was made that there was an earth change permit that was actually issued, and that the appeal before the BLUA was imminent. Therefore, we need this extraordinary relief in order to pursue the appeal. The Superior Court entered the TRO immediately, came to a hearing April 26th. The DPNR testified they had issued no such earth change permit yet. The TRO was dissolved. The court told the parties try and work this out, and the case remained stale until May 24th, 2019. That's when they filed a second motion, again representing that an earth change permit was issued. This time it actually was. It was issued May 17th. And that they were imminently filing appeal before the BLUA. No such appeal was ever filed. In the weeks that transpired between when the Superior Court, the complaint was first filed, between when the two motions for a TRO were granted, and all the time that elapsed when the court was hearing evidence, and that transpired over, I believe, from June to July. It was never done. And so the idea that you're going to come to court, invoke the court's jurisdiction, and then ask for an extraordinary relief of an injunction based on the represented pursuant to Rule 11 that this appeal was going to be imminent and never filed the appeal, I don't see how we can say the Superior Court erred in anything that they did. And the time to file that appeal before the BLUA lapsed before the Superior Court had even entered judgment, ruled on the preliminary and permanent injunction. The BLUA is by statute required to resolve these issues within 30 days. All of that would have been done before the Superior Court ever issued its memorandum opinion in this case. But the BLUA did nothing because the appellants did nothing. And the appellants raised a whole bunch of issues about due process before DPNR, and they weren't given due process before DPNR. I find that to be incredible for one reason. April 24, 2019, they made a representation of the earth change permit was issued. They knew by April 26 that it was not. DPNR didn't issue that permit until May 17, weeks later. What did they do in those intervening times? Why did they not bring the DPNR before the court or ask the court to enjoin DPNR during that period of time? DPNR was a party to the case, and they dismissed DPNR from the case and told the court, oh, we don't need DPNR here. But on appeal, they're making these bold claims that they were denied due process when they could have had due process before DPNR if they wanted it, and certainly before the BLUA if they had even filed an appeal. So I think all of these arguments about due process, and it's just frivolous, and the court shouldn't entertain it at all. With regard to the consolidation of the trial on the merits, first of all, Rule 65 is clear that that is permitted. I have the rule right in front of me. I can read it to the court if they want to. But
No. Attorney, you don't have to read it because I'm looking at it now. It's Rule 65A12.
Yes.
If we talk about the federal rules of civil procedure, and if we adopted that rule for the Virgin Islands rule of civil procedure, then it simply says before or beginning the hearing on a motion for preliminary injunction, the court may advance the trial on the merits and consolidate it with a hearing. And the heading is consolidation, consolidating the hearing with a trial on the merits. So it's clear, and this rule has been around since Noah built his act in the federal rules of civil procedure.
Yes, this is not a new rule.
Because I remember from back in the 70s, I always consolidated. So I was just shocked when the attorney suggested that somehow the court might need permission to do the consolidation.
And there's no jury trial with regard to preliminary injunctions and permanent injunctions. Those are judge-heard issues. Now, and on JA 11, I just want to bring to the court's attention, even with regard to the trespass claim, they specifically asked for the court to enter judgment permanently enjoining defendant from trespassing over plaintiff's property. So even with regard to the trespass claim, which is count 4, which really should, no, it was count 5, which really should have been count 4, there were missing counts. Even with regard to that trespass claim, they asked for an injunction, injunctive relief. Injunctive relief are issues that the judge determines. So the idea that they were, in addition to our waiver claims, because we have a whole section in our briefing about the fact that none of these issues were raised before the Superior Court, or even in their first notice of appeal, they just appeared in the briefing that the issues are waived. Notwithstanding our waiver argument, they asked for injunctive relief on the trespass claim. So every claim that was before the Superior Court was a judge-heard claim. And the standard error, did the Superior Court commit clear error? No. There was overwhelming evidence that this easement existed, that there was a clear right of way for him to be able to clear that road. There were so many witnesses.
But was there any, couldn't it have been abandoned? I mean, this is a private road.
No, they admitted, I'm sorry.
I'm saying this is a private road right of way that could be abandoned. And after all of these years, wasn't there a good argument that it was in fact abandoned?
Well, the Superior Court rejected that argument based on their admission that it was not abandoned. They actually admitted, and we cited to the admission, that there was no abandonment. Mr. McKenzie himself testified that he purchased he switched land with another plot owner to be able to develop a different road, but he admitted that he never gave up his claim to be able to use the established easement that was there.
So how about the septic tanks and the whopper poles that is in the right of way?
Well, the septic tanks were encroachments by the owners who improperly encroached on the easement. And if we're opening the door where people can just disregard easements in order to put steps for their property and septic tanks, then we'll just throw the whole property law into disarray. The appellants could have called WAPA as a witness to say that somehow the WAPA pole cannot be relocated. There's no evidence that these things are not, simple fixes. There was I'm sorry.
Couldn't, if it was more than 15 years and that couldn't it be, even by adverse possession, and wouldn't that be evidence going towards the fact that it might have been abandoned?
Well, the sole evidence that it was abandoned was that there was I think there were 2 witnesses that testified, alleged that it was abandoned, but it was not, because I think it was Mr. McKenzie that testified that he could use it to walk and hike, but not for the road purposes. And that was evidence that the Superior Court rejected. There was conflicting evidence. We believe there was an admission that it wasn't abandoned, and the Superior Court was as a fact finder, was free to say no. There wasn't clear error.
Attorney, if I understand correctly, Mr. McKenzie says, I still reserve my right in the original right of way or easement, but I personally decided that I will work out an arrangement with one of the nearby landowners to use an alternate route. but he never abandoned or relinquished whatever rights he might have had in the right of way. Now, the thing that I am looking at the map and I'm trying to, where was this place so steep that nobody could have cut a road? I'm trying to discern on the map, if you have the map in front of you, as to where was it, because a whole lot, much ado is made of the fact that if Mr. CUFFY is not allowed to use this right of way, that go back and follow all of the maps according to cadastral and according to the public surveyor and others, that one of the reasons why that he has to use that is because to cut where they wanted him to cut would have been too steep, or would have involved a whole lot of monies and whatnot. And I'm trying to discern for myself on the map, where is this thing? But all of those landowners, whether it be plot 5, 6, 37, 8, 7, 12, all of them, if they gone to the title to the property, they would have seen that there was in fact a right of way on the map. And
they purchased it. They purchased it subject to that right of way. And that's, I guess,
who was supposed to build the road?
Anyone who wanted. There was no homeowner association, so anybody who needed access to their property could clear the land and build the road. And Mr. CUFFY was the one. He testified. He had testimony on this.
Who's going to maintain it? Do you have the right to make everyone else contribute to the maintenance of the road?
Well, those issues were not developed before. It wasn't raised by any of the appellants that they were going to be forced to develop the road. But even if they were, they purchased their property subject to this easement. It was a part of and I would think that the purchase price they paid had considered that there was an easement over their property. So I don't think that it's even if they were responsible as part owners of this road to pay for, help maintain, or they subsequently formed a homeowners association assessed dues to maintain the road, that doesn't prevent Mr. CUFFY from accessing the property through the easement that was clear. Everybody testified that when they did their surveys on the property, it was clear that the easement was there. And for us to now, as Mr. CUFFY has now purchased the home and needs the property and needs to use that road to access his property, for them to now say that the drawings, and I think it's Public Works drawing 21, I wrote down the exact drawing number, 2161, they examined all of the drawings. All of the people that testified examined the drawings and said that easement existed. So you cannot, as a landowner, purchase a property knowing that that easement existed, purposely encroach on it in violation of the easement, and then claim foul once another landowner who purchased a property and needs that easement.
Did the BABJIs plead abandonment of the easement?
I didn't see that in the, I did not see that in the pleadings. I know there was testimony in the record about, there was a claim of abandonment, but it was conflicting. And at one point in time, they admitted it wasn't abandoned, but no, affirmatively pled. I don't believe I saw that in any pleadings. I believe there was representation that there was an alternate road that was there, but at trial, there was no evidence presented of this alternate road, or that alternate road was somehow superior or equal to that which was there under easement.
Well, attorney, if in fact, as I understand that plot number 38 is the one owned by Mr. CUFFY, there appears to be a sort of a road or something on the back part of his property, but that's not neither here nor there. But let me ask you this: to what extent, if anything, should we delve into the restatement toward insofar as concerning servitude 2.15 and 2.13? Because the one talk about servitude created by necessity, and I think that this is what Mr. CUFFY might want, or servitude implied from maps or boundary references, because much ado was made that, well, they're relying on these maps there, but apparently the restatement talk about servitude implied from maps or boundary references, and I'm looking at a map, and it appears that this map go right up to Mr. Cuffy's property with a cul-de-sac. So I just want to know, I know what has been our policy on the
That's why I asked council to address our ruling in strike back, because in strike back, we specifically adopted that, I think it's 2.13 or whatever it is of the restatement third.
Right, right.
Had you
2.13.
looked into that, Attorney Lawrence?
I did not, I apologize. I did not. Which is strange.
Well, we are very surprised. We're very surprised.
Which is strange.
Because it was mentioned, and somebody mentioned it in the briefs or in the papers, and I said, gee, you know, when you look at 2.13 and strike back and 2.15, softitude created by necessity is 2.15, and 2.13 talk about softitude implied from maps of boundary references, and 2.13, it seems as if that both of them, but more so 2.13, run smack through this case.
Yeah, but I think the rationale was, I apologize for, you know, not being 100% on that case. The brain can get full at times, but the rationale was the facts that were, the evidence that was adduced during the hearings, the multiple hearings. There was no reason to go and consult all of this law to try and, this stuff was undisputed. There just is no dispute that there was this easement. They all testify that it existed. And there's no dispute that the drawings that appear, is 2161, demonstrates an easement. They all testify that when they bought their property, they knew that easement existed. So I guess because we were dealing with a certain level of facts that, you know, just did not rise to the level of there being an actual dispute here, that I didn't stress that case, but you know, if that case makes the arguments stronger in favor of the appellee, then of course we would adopt the court's rulings there, an application of section 213.
Well, this thing was never going to be settled because of something that initially started, an inauspicious meeting between the homeowners and Mr. Cuffy. I mean, I've never seen anybody do that, and that in and of itself would set the tone, because it was surreptitious, it was conniving, and it could be deemed to be treacherous. You don't invite somebody as a good old-fashioned neighbor coming to the neighborhood for cocktail and then gonna want them to sign, according to Mr. Cuffy now, I want them to sign off their rights to property. Some people get volcanic over that. And right then and there, that was all holds barred, because it's the way how it was done. It was surreptitiously, ignobly, and treacherously conniving.
No, my time is up.
There is no way that they were going to repair that.
Okay.
I wanted to close with this one thought, if I may. That was another thing that, you know, I guess I wasn't too concerned about the factual. You don't ask somebody to sign away something that doesn't exist. And the fact that they asked you to sign away just means that it existed. And
all right.
Okay, thank you. Attorney Manning, you may use your 5 minutes. You need to unmute.
I apologize, and thank you, Mr. Chief Justice. Justice Swan, it never happened. That meeting is a fact in dispute, and we dispute the facts that were adduced, and we believe that if a trial by jury would have happened, and this case was tried, a jury would have disagreed with that. It never happened. And it's our position, I understand strike back, Mr. Chief Justice, and I'd like to come right back to that. But as to Justice Swan's position, Rule 65A2 last sentence, we believe that supports my argument. And I am aware of Rule 65. I'm not arguing that the first few sentences require a waiver. However, but the court must preserve any party's right to a jury trial. We're talking about issues.
No. I'm not talking about a jury trial. I might understand you to suggest that the court might have that the court had to get permission from one of the litigants in order to consolidate. That was my argument, and I said, no, that's not true. So you know, that was my thing, because when I look at it, and I'm looking at it now, and it says consolidating the hearing with the trial on the merits. I mean, you can't get any clearer than that. That's the heading, and nowhere in that section does it say anything at all about getting the permission of the litigants or the litigants' attorneys.
I agree.
Regarding
Attorney
or
Manning,
I'm sorry.
go ahead, Justice Gibbons.
Okay.
I was just going to ask
Regarding-
him, didn't he waive the jury by proceeding with the understanding that it was going to be under merits, and really never raised it and only discussed it on the last day when the judge himself raised it? Did you waive that by participating in the action?
Absolutely not, Mr. Chief Justice. I think that when the court ordered, he ruled. He gave us no opportunity for input. So there's no opportunity to object. Once the court rules, the only other option you've got is to come to this court right here. I mean, otherwise,
You better.
Go ahead.
You better object. If not, you don't come to this court, because if you don't raise it below,
You gotta
can't raise
resolve
it.
it.
Mr. Chief Justice, if the court rules without giving us an opportunity to speak, how can we object?
You were in the trial for a whole day. You could have raised it at some point.
Well, we've raised it through Rule 38, and Rule 38 clearly requires consent from both parties, and we never gave the consent.
Mr. Attorney Manning, with regard to the our Striebeck case that just issued,
Yes.
you have an entire portion of your brief dedicated to the restatement 2.13, and your argument is that because we have not adopted that restatement via a bank's analysis, and you're claiming that the court used it, that the court erred. What is your position now that we have adopted that portion, section 2.13 of the restatement?
It's our position, Justice Cabret, that our argument still stands. I understand that you've adopted it in Striebeck. At the time, we argued it, but as it is right now, it is the appellee's burden to establish the easement. And then we have the right then to challenge it through abandonment.
The appellee did not file a counterclaim. The appellee was simply defending in this case.
Right.
And this is within the context of an injunction.
Madam Justice.
So why does the appellee have a burden to establish anything other than defend?
Well, we argued that he was trespassing. Therefore, to argue that he wasn't trespassing, he had to establish that he had an easement. And then then the burden shifts to us to prove he didn't. So the burden shifting analysis was improper in this case. We were essentially required to prove that he didn't have an easement. And that's
But
not how the process
you don't
works.
make that argument. You didn't make it to the court, and you certainly don't make it at this level.
We argued that he had no easement. We argued that he was improper.
I'm sorry, sir, Attorney Manning.
Yes.
You know, the appellants in this case have been like a moving target. The arguments, I mean, my point is that you never told the trial court that the burden was on Mr. CUFFY to establish that he had an easement. And you never argued that. You never argued that burden shifting that you're arguing to, that you're articulating now. Is it anywhere in your brief?
Madam Justice, it's understood. If we argue that he has no right to the land, he has to prove that he does have a right to the land. I didn't think that we were.
I'm sorry, it's understood?
Absolutely, Madam Justice. If I argue that you have no right to be on my property, you have a right to prove that.
How do we? I mean, I'm truly perplexed now. How does this court review an understanding?
It's just, to me, it's an elementary rule of law that if I argue you have no right to be on my property, you would then have the burden or the obligation to prove that you have a right to be on the property. And you can do that by saying I've got an easement, or I've got a license, or I actually own the land, or I have some other reason or justifiable basis to be on said property. And in this case,
You're saying that you can file a claim and expect the defendant to come in and prove your claim?
no,
I thought, I thought the law required that the plaintiff prove the affirmative and prove every element of their case. So if you are proving that they do not have an easement, it would be your burden to prove that, not for them to come back and prove that they have one. I mean, they can come back and do that, but your burden, if you don't prove that they didn't have it, then you haven't met your burden of proof.
Mr. Chief Justice, my argument is, if I argue trespass, I'm arguing he has no right to be on my property.
Right, you have to prove that. You have to prove that. You don't have to, they don't have to come back and prove that they are not trespassing. You have to prove that. If they do nothing and you haven't proven the affirmative of your case, I don't see how, but
Mr.
you
Chief
just wrap it up so that we can finish this. You're 2 minutes over.
I apologize. I was just responding to the questions. I had a long way to go, but I wanted to make sure I address these concerns from the court. To prove that that's my land, all I need to do is show you a deed. That's it. He would then have to show that he's got a right to my land or right to access my land. And that's my argument. We introduced our deeds and we showed that that is our land. So a right to land, an easement or otherwise, it's his burden. Our position is we agreed that there was a line.
Your deed referred to a different map?
It did, 1407.
And that did not show the road?
We argue that this case was a shotgun trial, tried 10, 14, 15 days after it was filed. It was
All right, I understand that. So let's just, if there's nothing
You
else.
never answered the last question, Chief, and that was important. Whether or not, if you use a different map from what Mr. CUFFY was using, whether or not there's a right of way on his map.
If you use
Never answered that
1407,
question.
if you use 1407, Justice Swan, you will find there was no reference to an easement at that time because.
But did the map show it, regardless of reference? Did it show that easement?
It would not show it. That's my argument. But it was tried so fast that we didn't get a chance to properly develop the record.
Okay, thank you.
Thank you, Mr. Chief Justice, and thank you for your time. I understand, and I appreciate the court's time.
Okay, the matter is submitted.